Welcome to Talk Tickers, the briefing where we distill the complex legal and financial maneuvers that are, actively shaping capital markets.
Today, we're really taking a look at corporate distress. We're focusing on Chapter 11 bankruptcy.
Right.
But not just as a legal failure. We're looking at it as a mechanism for survival, kind of a planned financial reset button.
A reset that can dramatically alter the risk landscape for everyone involved. Debtors and creditors alike.
Exactly.
So our mission today is to walk you through that whole life cycle, from the immediate life-saving actions they take all the way to the final plan confirmation.
And we'll also highlight the massive, game-changing advantage that Subchapter V has introduced for smaller companies.
And what that means for you if you hold their debt or, their equity.
So let's start with the basics. Chapter 11 is fundamentally a reorganization. It's not like Chapter 7, which is just
straight liquidation, sell everything off.
Right. The goal here is preservation. You file, you negotiate, and you try to execute a plan that allows a distressed business to keep operating.
And for investors, I think it's crucial to understand that the outcome is pretty binary. A successful reorganization means the business comes out the other side, maybe with a new structure, new management, but its value is saved.
But if they can't put a feasible plan together, one that creditors will accept, the case gets converted to Chapter 7.
And that's the death blow. Assets sold off, company's gone.
We should probably clarify this idea of debt discharge. Businesses don't get a fresh start in the same way an individual does.
That's a good point.
But debts are routinely discharged or wiped out in Chapter 11. It's not magic. It comes from intense negotiation with creditors.
And the most common way we see this in public companies is the debt for equity swap. Right?
Exactly. So if you're a junior debt holder, instead of cash, you might get offered, say, a percentage of the equity in the new reorganized company.
And in exchange, you waive your original debt claim. That's the discharge. You're converting a legal obligation into stock.
Yeah. And while that's good for the company trying to survive, if you're an existing shareholder, well, that swap is massive dilution.
Oh, your legacy equity is often completely wiped out. Or, reduced to a tiny fraction of a percent of the new company.
There really is. It's essentially a transfer of ownership from the original shareholders to the former junior creditors.
And this whole playbook, this sort of established process, has been fundamentally changed for smaller businesses.
That's where Subchapter V comes in. The Small Business Reorganization Act of 2019, or SBRA, created it.
And it's designed to be, streamlined, more cost-effective?
Far more. It was made specifically so that smaller businesses could actually afford Chapter 11. The traditional process was just too expensive, too time-consuming.
And there was a temporary policy change that really mattered here, wasn't there?
There was. When the pandemic hit, the CARES Act temporarily boosted the debt limit for Subchapter V up to $7.5 million.
Which is a big number.
A huge number. And even though it was temporary, until March 2021, it just widened the door dramatically. It wasn't just small shops anymore. It was significant mid-market firms using this faster, cheaper process.
So let's back up a bit. Why does Chapter 11 even exist? Why not just liquidate everything from the start?
It's pure economics, really. Creditors often agree that a business is worth more alive than dead.
As a functional breathing operation?
Right, more than the sum of its parts sold off for scrap. A Chapter 7 liquidation almost never gets everyone paid back in full, especially if the value is in things like IP or customer relationships.
Exactly. So they're betting that letting the business restructure will maximize their long-term recovery.
Now, even before they file, these companies are already in crisis mode. Cash is tight. Credit is drying up.
They're exploring everything. And if bankruptcy looks inevitable, they try to shorten the process as much as possible.
And that's where you see prepackaged or pre-negotiated bankruptcies.
So they work out a deal with their main creditors before they even go to court.
That's the idea. It can cut the time in court from over a year down to just a few months. For investors, that means less uncertainty, less cost, and a faster path to knowing what your claim is worth.
But the second that petition is filed, everything changes. The company gets its lifeline, the automatic stay.
It's like a financial force field, a court injunction that just halts most collection activity. Lawsuits, garnishments, it all just stops.
It stops the clock.
It gives the debtor crucial breathing room. They can stop worrying about being sued and start focusing on the reorganization itself.
But that breathing room is useless if they can't stabilize the business, which brings us to the critical first day motions.
Think of it like a corporate ICU checklist. They need immediate permission from the court just to function.
And one of the first things is getting permission to use their cash collateral.
Right. And in practical terms, that means revenue from assets the bank already has a lien on, like accounts receivable.
So the money coming in.
Yeah, the debtor needs that cash to pay bills and keep the lights on. But the secured creditors technically have a right to it. The court has to approve its use.
They also need new money, which is where debtor-in-possession or DIP financing comes in.
This is brand new money, usually from a hedge fund or a senior creditor, specifically to fund operations during the bankruptcy. And this debt is super priority.
It gets paid back first, before anyone else.
Before even the old senior debt.
Yeah.
And, if a company can't get DIP financing, that's a really bad sign. The market is basically saying it's unsalvageable.
And the other big motions are about paying employees what they're owed, and maybe most importantly, paying critical vendors.
Oh, absolutely. If you can't pay the key suppliers in your supply chain, the business just grinds to a halt instantly.
Okay, so once the company's stable, the real negotiation begins. And that's all dictated by the debt hierarchy.
Yes. For you, the investor, knowing where you sit on that ladder, the absolute priority rule, that's everything.
And the rule's pretty simple, isn't it?
It's ironclad in a traditional Chapter 11. Senior debt holders banks, secured creditors, they get paid first.
And junior debt holders, like unsecured bond investors, get paid last among all the creditors.
And then way at the bottom are the equity holders, the shareholders.
They only see a penny if every single creditor claim, senior and junior, is paid in full. It is, the absolute worst place to be.
Let's use a quick example to make that really clear. Now, imagine a company owes $1,000 total. $400 to senior creditors, $600 to junior bondholders.
Okay.
But when the company is liquidated, it only brings in $500.
So the senior creditors get their full $400.
They get their $400. But the junior creditors only get the $100 that's left over.
Leaving them with a $500 loss.
Exactly. And that brutal reality, that deficiency, is what dictates all the leverage in the negotiation. Those junior bondholders have very little power.
So their only real option is to negotiate for that debt for equity swap we talked about.
Right. They're hoping the stock in the new company will one day be worth more than the $100 in cash they'd get otherwise.
So after that initial crisis, existing management keeps running the business as the debtor-in-possession, or DIP.
The business looks the same on the surface, but legally, management's main duty is now to the creditors, not the original owners.
And there's oversight to make sure of that.
Immediate oversight. The Office of the U.S. Trustee appoints an official committee of unsecured creditors, the UCC.
Which is usually what, the 7 biggest unsecured creditors?
Usually. And they act as fiduciaries for all the unsecured creditors. They hire their own lawyers, their own accountants, and the debtor's estate pays for it.
So if you're holding junior bonds, but you're not on that committee, the UCC is basically your proxy, your representative in the room.
That's right. You're relying entirely on their skill and their diligence to negotiate the value of your claim.
And all of this negotiation leads to the plan of reorganization. This is the roadmap out.
It is. It details how the business will restructure debt, sell assets, and handle repayments over time.
Yeah.
But before creditors can even vote on it, the court has to approve a huge document called the disclosure statement. The disclosure statement is key because it has to provide adequate information. It lays out the plan, a liquidation analysis, what you'd get in Chapter 7, so you can make an informed vote.
And the plan has to be accepted by a majority of each class of creditors whose claims are being impaired, so not being paid in full.
But there's another really complex part of these plans that can trip people up. Third-party releases.
This is a huge flashpoint in restructuring today. They're often buried deep in the documents.
And what do they do?
Essentially, they can state that if you vote for the plan, you are also releasing non-debtor parties, like directors or advisors, from any future liability.
Unless you actively opt out.
You have to actively opt out. If you just accept the plan and don't check a specific box, you could be giving up valuable legal rights. You have to read the fine print. Okay, so if traditional Chapter 11 is this grinding, costly legal marathon, Subchapter V is the express lane for small businesses.
It really is. The first big difference is the timeline pressure. In a traditional case, you might have a year to file a plan. Under Subchapter V, you have 90 days.
90 days, that's incredibly fast.
It is, and extensions are really restricted. It forces quick negotiations and saves a ton in administrative costs.
And while the debtor is still the DIP, there's a trustee involved.
A trustee is mandated in every Subchapter V case, but their job is to monitor and help facilitate the plan, not take control of the business.
But the single biggest change, the real game changer, is the elimination of the absolute priority rule.
This is it. This is the core difference. Under Standard Chapter 11, if creditors aren't paid in full, the equity holders get wiped out, period.
That's the absolute priority rule. You can't keep your ownership if someone senior to you isn't made whole.
Subchapter V just throws that rule out for small businesses.
So what does that mean in practice?
It means the debtor can confirm a plan, what's called a cram down, over the objection of creditors.
As long as the court thinks the plan is fair and equitable and likely to succeed.
Exactly. And the consequence of that is monumental. The existing owners can actually retain their equity, keep their business, even if some creditor classes aren't paid in full.
That is a massive shift in power away from the creditors and back to the founders.
It's the primary reason we've seen such a surge in Subchapter V filings. It dramatically increases their chances of surviving with their ownership intact.
Okay, so for those of you tracking firms in financial distress, looking at their strategy, there's really one key question you need to keep in mind.
And that is the company using Chapter 11 just to manage old debt? Or is the filing a trigger for a fundamental, necessary shift in its actual business model?
That distinction is everything, isn't it? A reorganization that only shuffles debt but doesn't fix a broken business is just, delaying the inevitable.
A truly successful reorganization involves huge operational changes. Plant closures, selling off divisions, leadership shakeups. That's what impacts future earnings potential far more than the old debt ever did. You have to look beyond the balance sheet.
Right.
So to summarize our look at all this, Chapter 11 is the legal framework for corporate reincarnation, really. It's a high-stakes negotiation governed by the automatic stay and the plan process, where debt priority is king.
And for smaller and mid-sized businesses, Subchapter V has permanently changed the calculus. It's expedited, it has trustee oversight, and it has that stunning ability to confirm plans over creditor objections while letting owners keep their equity.
It's created a whole new, faster risk profile for investors in that part of the market.
And it leaves you with a final thought to mull over.
I think so. The speed of Subchapter V is something to consider. Because these smaller businesses can reorganize and emerge so much faster now, what does that do to market efficiency when it comes to pricing their distressed debt?
Are we even giving investors enough time to properly assess the risk before a whole new company emerges from the process?
It's a question worth asking.
Thank you for joining us for this deep dive into corporate reorganization. Stay informed, and we'll catch you on the next briefing.